Hello again, my name is Eric Willison, and this is Fatlock on Evidence. Now, we talked in past videos about the first thing we look at is whether the evidence that we want to get into court is relevant evidence. If it's relevant evidence, then it comes in, unless there's a rule against it. And one of those rules would be the 403 rule, where we talked about whether something was unfairly prejudicial, would confuse the jury, is repetitive, and that sort of thing. That's a different video. The next rule we came across is hearsay. If something is an out-of-court statement by a declarant and it is trying to be let in for its truth, the one side is trying to get it in for the truth of what it asserts, then it can't come in unless there's an exception to the hearsay rule. And there are several exceptions which we're not quite ready to get to, because we still have to get in what is an out-of-court statement. Now, it would seem pretty obvious. Somebody says something out of court that's tried to get in for its truth. Well, then there it is. But what happens if the person doesn't say anything? What happens if it's just what's called assertive conduct? So, real simple thing is, I asked her if the suspect was in the lineup, says the police officer from the stand, of the victim of the crime. So the victim of the crime in this case is going to be the declarant. And the prosecutor says, well, what did she do then? And the police officer testifies, well, she pointed right at the defendant like that. Well, that's assertive conduct. That's the declarant saying something, not with her vocal cords, but with her finger pointing. She is meaning to tell us something, that that's the guy that stole her purse, that's the guy that hit her, that's the guy that did the bad thing, okay? So she doesn't have to say anything. That can still be hearsay if it's assertive conduct. And if that's the case, then we're going to have to search for an exception to the hearsay rule for that to get in. All right? Second very obvious answer, or obvious example would be maybe in a civil case. I asked her if she was hot. Now, normally you don't have to ask a girl if she's hot. You can tell just by looking at her. You know, a lot of hot girls out there. But I think what this lawyer is saying is, was she feeling the temperature and the humidity? I asked her if she was hot, and the lawyer says, well, what did she do in response to your question? Well, she shook her head from side to side. In other words, no. That shaking your head from side to side, clearly assertive conduct. She's trying to assert that the temperature, the high temperature, was not bothering her. She was not hot. Now, that's a clear example, which I give so that I can give you a very, very closely related example that is much more problematical, okay? What if the question was, I asked her if she was tired. Well, the attorney says, what happened then? And the witness says, she was nodding her head up and down. Now, that could be simple. It could mean, yes, I'm tired. You nod your head. But what if it wasn't an answer because the witness never even heard the question, because the witness was so tired that she was in that state where her head kind of drops like this, and, wake up a little bit, and then you sort of drop again, that sort of thing, where you get the nods, they call it, okay? Well, that nodding your head up and down could be a non-assertive, just a reaction, the body's natural reaction to fatigue and being tired. So we don't know whether the nodding was an answer, which is out the door, you pixie, unless we've got some sort of an exception to the rule, or because it's hearsay, it's assertive conduct, or maybe it should get in because here's a person who is describing what somebody else is going through. And they're asleep, or so close to being asleep that they're not even trying to answer the question. They never even heard the question. So that gets a little bit closer. So then we talk about something that's even trickier, okay, which is the sounds of silence. Now, I'm not talking about the Simon and Garfunkel song. I'm talking about whether silence can be hearsay or not. Well, how could anything be hearsay if nothing was said and nothing was even asserted by a shake of the head or an up and down or whatever? Well, let's think of this example, okay? Police are suspecting two people of being involved in the drug trade, and they are presently chasing them in a foot chase. And the police officer comes around the corner, and here are the two guys standing on a porch, and they're sort of acting nonchalant now as if they were not the ones being chased. But he sees one of them take something and kind of go like this, whoop, and sort of throw it off to the side and into some bushes down there. Now, the police officer, he thinks it's crack. Now, obviously, once he runs up on them and he's got his gun out, they're under arrest at that point, and he's saying, okay, which one of you has crack, and nobody's saying anything, okay? Well, we certainly can't use, let's say that only one of them right now is being charged. The guy on the left, we'll call him Lefty. So Lefty's being charged with the crack. For some reason, the guy on the right, Righty Bulger, we'll call him, Righty is not being charged. Maybe he's an informant or something. But so we don't want to use Lefty's silence against him because, as we'll get into in the Fifth Amendment, which is not part of evidence, but it is part of criminal procedure, that'll be a whole other set of tapes. But you can't use a suspect's exercise of his right to remain silent against him. You can't even mention it to the jury. Okay, so to get around that, we're going to have in our example, we're going to have the police. He's just going to question not Lefty, the suspect. He's going to question Righty Bulger, and he's going to say, "Hey, you, was that crack you just threw into the bush?" And Righty, who knows his Fifth Amendment rights real well, just stands there looking at him. Doesn't say yes, doesn't say no. He takes his upper lip and he presses it firmly against his lower lip because he knows that's what makes his attorney happy later on if it goes to a trial. Shut up, don't talk me, you can only hurt the ball club. That's what's going on in Righty's head, okay? So he just shuts up, doesn't say anything. Now, the prosecutor wants to use this silence as evidence to the jury that this guy knew that he had crack and that he was throwing it away into the bush. Now, let's also say, just for the purposes of our example here, that they searched the bush very, very carefully, but they couldn't find the crack. Maybe it was wet down there and it dissolved, I don't know, but they just couldn't find it, okay? So they really need evidence that that was crack, and they want to bring to the jury the idea that because Righty would not testify and say that, no, it wasn't crack, he just remained silent, that meant it was crack. Now, the defense lawyer for Lefty is going to get up and he's going to object. He's going to say, "Hearsay, Your Honor." And his honor is going to say, "What do you mean hearsay? Your guy didn't say anything." Well, that's right. And Righty didn't say anything, the judge is going to say. "That's correct, Judge," says the attorney. But the problem is that the prosecutor is trying to get in evidence of what the silence meant, what was intended to be conveyed by righty. And what was intended to be conveyed is that was crack, and I'm not talking about it. I'm just shutting up, sir. So in that way, the defense attorney for Lefty is asserting we've got assertive conduct here through the silence. Through the silence. Now that's going to be probably a little bit of a hard one for that judge, because it is assertive conduct, but nobody is asserting and nobody is speaking. Nobody is conducting. So in the one case in Ohio that addressed this that I saw, what the judge said was, you know what, it might have been hearsay and it might not have been hearsay, I don't know, but you know what, I'm going to apply Civil Rule 403, and I'm going to say that it is kept out because of 403, because it's going to unfairly confuse the jury as to how much weight to put on that, okay? So you always want to remember in these situations where you've got assertive conduct, or whether you're trying to say that something is hearsay, you're always trying to go back to the basics of hearsay, which is, why don't we want hearsay coming in the first place? As you'll remember in our previous video, we don't want hearsay coming in because we don't know what the declarant was really meaning when he said or didn't say those things, okay? So in this case, we don't know whether Righty Bulger was exercising his right to remain silent under the Fifth Amendment, or maybe he just doesn't like police officers, and if they'd have walked up to him and said, hey, who do you think's going to win the Ohio State game this weekend? He'd have just stared at him. Maybe what he had in his pocket, he thought it was crack, but in reality, it turned out he'd been ripped off and he had fake crack. We don't know. So he tossed it either way. So we don't know what was meant by the silence. And so the attorney who's looking to keep the hearsay out still always has to go back to the problems that just naturally flow from hearsay evidence, which is we don't know what they meant. We never get a chance to cross-examine them about what they meant in most cases. And it's situationally dependent. And you're having somebody else, like the police officer in this case, interpret the situation of somebody else whose mind that police officer can't read, or doesn't have to be a police officer, that person can't read. So go back to that, argue that hearsay evidence, if it is hearsay, is just too problematical for those bases. And if you can sling another rule in there like 403, hey, it's too prejudicial, Judge. The relevancy of the evidence, the probative nature of the evidence, the power of that evidence is outweighed by its tendency to confuse the jury about the issues, to unfairly prejudice the jury about the issues. Maybe it's repetitive, maybe it's whatever. You go through all of those arguments as well, okay? And then, if it is deemed to be hearsay, then you're going to have to go through all the hearsay exceptions as well and see if any of those apply. We've only gotten to one or two of the hearsay exceptions so far, just by way of earlier structural example. We're going to be getting into those next, well, not maybe in the very next video, but very soon we're going to go through each of those exceptions very carefully and thoroughly, and then you'll know what there is to be known about hearsay. So, again, I'm Eric Willison. This is Fatlock on Evidence, and we'll have another video soon.